we won't have that person here. We only have two presentations. And the first one is by Tsepho Mongalo with the title Possible Contribution of Corporate Law Remedies to Curbing Illicit Financial Outflows of Capital from Africa. So welcome and good luck.
Good afternoon, ladies and gentlemen. It gives me a great pleasure to be talking about this subject of illicit outflow of capital out of Africa, particularly befitting on the day on which South Africa celebrates 20 years of constitutional democracy. And although it seems like yesterday, but a lot of strides have been made. And a lot of what I'm going to say is going to be based on what has happened within the context of the constitutional democracy in South Africa and how it can affect similarly situated countries that are suffering from this phenomenon of illicit outflow of capital. Now, I think to start, I must just introduce myself to say I'm Tsepho Mongalo from Wits University, and it is actually my first time here in India, and I would like to extend my gratitude to the organizers of the conference for having invited me to come and talk on this subject. The one thing that I would like to say is that many of you who probably know this subject from any other perspective, other than from the company law perspective, you will pardon me if maybe sometimes I use terms that are not familiar with you, but what I plan to do is to try to simplify the presentation well enough for you to follow what I am talking about in relation to the impact of corporate law, and I hope that we will have a lively discussion after I would have presented. Now, this is seriously a menace within Africa, the topic of illicit financial outflows of capital. And the recent study by the GFI, the Global Financial Integrity, has revealed that between 1970 and 2008, the illicit outflow of capital from sub-Saharan Africa, or not only sub-Saharan, the whole of Africa, actually exceeded $850 billion US, and they even say that that is a very conservative estimate. And they also say that the possible total funds that could have left the continent could be well in the region of 1.8 trillion between those years. And sub-Saharan Africa has suffered a greater loss with regard to capital outflow. Now, they are giving the definition of capital outflow or illicit money as money that is illegal in nature in the form of its movement and its use in the country where it is intended to go, and as long as it breaches the law in the country in which it emanates, it actually is illicit money. Now, recently the United Nations has constituted a high-level panel on illicit outflow of capital out of Africa, and it is led by the former president of South Africa, President Thabo Mbeki. And recently, when he was speaking at the United Nations, he said that this is money that is generated within the country. It belongs to the country, or it belongs to the continent, and then it leaves through illicit means. And therefore, part and parcel of the scope of their mandate is to find out the impact that it has and make recommendations as to how that illicit outflow of capital out of Africa can be dealt with. Now, what is interesting is that of the top 5 countries in Africa that are suffering this, South Africa features at number 5, with Nigeria, unsurprisingly, at number 1. And recently, actually last night, Al Jazeera News reported one of the things that are happening, that it is losing a lot of money, possible tax money, as a result of illicit outflow of capital through the oil that is sold by oil companies to their subsidiaries in Europe at a price less than the value of the barrel, which is then sold to the US at the market value. thereby robbing the country of profits which are not accounted for because of the activities of devaluing the oil that leaves the country. And obviously they're doing this in collaboration with state officials, and that needs to be actually resolved even at the level of state officials. Now, research also shows that the illicit outflow of capital actually outpaces official development assistance that is given to the region by a conservative estimate of 2-to-1. And over the years that they have actually been looking at this phenomenon, they are of the view that it has been increasing by a high percentage or point of 11.9, making it quite a very serious challenge for the continent of Africa, and I think maybe even for other developing countries as well. Now, just to say that a large proportion of this illicit outflow of capital is made up of activities of the multinational corporations, as I've just given an example in the case of India, by underpricing the imports and overpricing exports to avoid custom duties, and by underpricing of natural resources sold to subsidiaries or related companies outside Africa to avoid paying income tax. And that they do quite consistently and constitutes a large portion of this up to 65% of the capital outflow. Now, the basis of my paper today says that this practice, if detected, has the potential of negatively affecting not only the companies and their shareholders, but also other constituencies that are somehow linked to the company, either through being the employees of the multinational corporation itself or the subsidiaries of the multinational corporation. And it can also affect badly the creditors of the companies or the group of companies, and can affect the suppliers and the society at large, the public at large, particularly the states in which the illicit outflow of capital is taking place. And this is quite at the heart of my argument that the impact of this is actually greater than just to the companies and their shareholders. But at the same time, we find that the corporate legal enforcement framework basically still is based on the legal enforcement framework that emanates from the 19th century company law of Anglo-American jurisdictions, particularly for the sub-Saharan countries that are following English law insofar as companies are concerned. And this legal framework is basically directly favoring one form of investment within the company, which are equity investors and simply shareholders, insofar as the enforcement is concerned. And the corporate legal enforcement framework is actually constituting two main actions. I can say them that they are, firstly, the personal action, and secondly, the indirect action. The direct action, which is personal action, is for the vindication of personal or collective rights of the persons affected, and usually it is limited to enforcement by the shareholders. And the second one is called the indirect action, and that's why the term derivative, meaning derivative proceedings that are brought about on behalf of the company by whoever is entitled to do so. Anglo-American corporate law is actually still saying that it is the shareholders who may be able to bring derivative litigation and not any other corporate constituency. And given the fact that in the context of illicit outflow of capital, the affected constituencies are not only limited to the shareholders, this is quite problematic. And indeed, the justification for this very conservative and individualistic approach to enforcement of company law insofar as direct actions are concerned is based on the fear of floodgates of litigation, which, as they argue, as many people argue, can be caused by frivolous and vexatious litigation that can be brought about if the number of constituencies is extended beyond just the shareholders. Now, the corporate law developments, particularly in South African context, show otherwise, that there are alternative ways of curbing frivolous and vexatious legislation, for an example, by certification requirements with preconditions, as provided for under Section 157 of the Companies Act. And this can be something that can be followed in Anglo-American jurisdictions, particularly because, in the first place, there are other ways in which those Anglo-American jurisdictions can be able to avoid frivolous and vexatious legislation. Firstly, the inherent power of the courts to throw away any vexatious and frivolous legislation. And secondly, the fact that through the legislation they can be able to even provide for certification proceedings or requirements which have got preconditions that are not based on the identity of the corporate constituency concerned, but are based on the impact that the activity may have upon different constituencies within the company. And research also shows that another justification for this indirect actions, which are derivative litigation proceedings, is actually based on the misunderstanding of the role of fiduciary obligations or the fiduciary law. Anglo-American jurisdiction conventionally understood fiduciary law to be for the exclusive benefit of the shareholders. And research actually shows that fiduciary law has been set out in order to restrain directorial self-serving misconduct, which does not only benefit the shareholders, but it benefits even constituencies other than the shareholders within the company, and even, you can say, the public interest. And therefore, the insistence on the Anglo-American, the 19th century Anglo-American philosophy of fiduciary law has been for the exclusive protection of shareholders is, with respect, misdirected. And as the basis for legal action or for corporate legal enforcement framework, it is not justifiable. And secondly, the issue of corporate voting or the exclusivity of corporate voting has been the basis for corporate legal enforcement, because it is actually a right or a privilege that is conventionally given to shareholders alone. That is also not justifiable in modern corporate law, because many corporate instruments are showing that the privilege of corporate voting is no longer just the exclusive domain or preserve of the shareholders. And in that regard, therefore, the justification of the current conservative legal enforcement framework based on the exclusivity of corporate voting is also not justifiable. Now, while we are of the view, indeed, that the illicit outflow of capital actually impact negatively upon constituencies broader than companies and shareholders, we need to acknowledge that there are some jurisdictions that have taken this into account. And the most important of which I'm going to discuss is the South African Companies Act. It came into operation on the 1st of May in 2011, but it is called the Companies Act of 2008. And it has actually reformed the direct action in company law by introducing extended legal standing with certain qualifications and preconditions that must be met. And this is based on the provision under Section 38 of the Constitution of the Republic. And the Section 28 is actually designed in relation to the enforcement of the Bill of Rights, which can actually be extended to the enforcement of other rights, like rights and interest within other areas of law than as company law. But it can be enforced by anyone acting in their own interest, anyone acting on behalf of another person who cannot act in their own name, and anyone acting as a member of or in the interest of group or class of persons, therefore introducing the class actions, and anyone acting in the public interest, and an association acting in the interest of its members. Recently, there's been a court decision that has interpreted this, and they have put into our corporate law a requirement insofar as public interest proceedings are concerned, that there must be certification by the court prior to giving the leave of the court for proceedings to be undertaken in public interest. And further, in acknowledgement of the fact that the role of fiduciary obligations is no longer just the exclusive protection of the shareholders, but the restraining of self-serving misconduct on the part of the directors, the Companies Act has also introduced an extended standing insofar as derivative litigation are concerned. And this is in terms of section 165, subsection 2, which basically says that in addition to the shareholders, directors, and employees, any other person may be able to serve a demand upon a company to commence or continue legal proceedings or take related steps to protect the legal interest of the company if the person has been granted leave of the court to do so, which may be granted only if the court is satisfied that it is necessary or expedient to do so. Now, looking forward then, using this particular justification, what would the enforcement framework of affected companies have to take into account in order to address the issue of illicit financial outflow of capital? That's if in the design of the corporate legal enforcement framework, the legislators by affected companies can be mindful of firstly, alternative means of capping possible floodgates of litigation and vexatious and frivolous proceedings, rather than just identifying a single investor within the company who will benefit from these proceedings, and restrain the fact that the role of fiduciary obligation is the restraining of directorial self-serving misconduct, not only for the benefit of one group within the company, but for a wider benefit. And also the disassociation of shareholder right of action with their conventional exclusive privilege of corporate voting. Then a more inclusive corporate legal enforcement framework suited to addressing this illicit capital flight out of those countries can emerge. And I would like to thank you.